Good morning and welcome to our first construction and engineering webinar of 2024. And thank you as always to CICES for having us along to present to you all again. My name's Catherine Andrews. I'm a partner here in the construction and engineering team at Birketts. If we could move to the next slide, please. Hopefully, most of you will have heard of Birketts, so I'm not going to spend too long on this bit, but just to say that we are a UK top 50 law firm, a full service law firm with 6 offices across the east of England, London, and most recently Sevenoaks, with over 1,000 members of staff across a broad spectrum of legal services. Next slide, please. I'll now take the opportunity to introduce our speakers today. So first of all, we have John Fawcett, who's the senior associate in my team and specialises in construction disputes. So he thrives on a good adjudication. We are then welcoming a guest speaker. This is Mark Upton, a partner at Ensors Accountants, who specialises in insolvency work. Many thanks to Mark for joining us today. And last but not least, we will have Kira Sharp, who is a solicitor in our team, also specialising in disputes work. Next slide, please. So just taking you through what we're going to look at today, John is firstly going to take a look at the subject of termination of building contracts and provide some advice on what and where, not what to do and what not to do should you consider that termination is appropriate. Unfortunately, it's quite a common topic for us at the moment with the uncertainties in the market. Linked to that, we then have Mark looking at insolvency, and he will take you through some of those processes. And then Kira will follow up with a few recent cases, which we hope will be of interest in the construction field. At that point, we'll all come back on screen for a short Q&A session. There'll be an opportunity to put your questions to our panel through the chat function on the GoToWebinar portal. Those come through to me anonymously, so please don't be shy. Feel free to send a question across. We may not be able to get to all of them, but we'll do our best, and we can obviously pick up queries afterwards if needed. We'll try to draw the session to a close promptly at 12. Other housekeeping points, the session is being recorded and will be circulated to delegates afterwards along with the slides. This should happen within the next week. Please also note that the session will be on the CICS YouTube channel for you to look at a later date. Next slide, please. So that's enough from me. I'm now going to hand over to John, who will present to you on contractual termination. Thank you.
Thank you, Catherine. So I've been asked to talk today about termination in contracts, and I think everybody will accept that it's a fairly uncertain landscape at the moment, and this is something we're having to deal with more and more. As Mark will come to in a moment, insolvency really is a constant shadow. I'm going to go through a broad overview of the sort of powers that you might have under your contract in order to try to get out of a difficult situation. I've got a couple of examples from both the JCT design and build contract and from the NEC 4 to help illustrate those points. Needless to say, it's a technical area with significant ramifications, so getting advice is usually essential. Next slide, please. So first thing first, when can you terminate? As you've all no doubt heard a lawyer say before, it depends. And here, it depends largely on the contract. In most cases, the written contracts that we usually work with, particularly the standard forms, contain express powers to terminate the contract. Those powers commonly include those that are set out on the slide. So termination for default, usually both ways, so employer and contractor, and then termination for insolvency, again, usually in both directions, and termination at will, usually, somewhat unfairly, only in favour of the employer. A lot of times, you're going to use more than one of these at a time, so we need to look really at their interplay as well as them individually. To the extent you have those rights, you need to use them correctly. So if you've got rights, but you don't then go on to exercise them properly, and you don't follow the contractual process, you will find yourself in repudiatory breach of contract for a wrongful termination. So you really will be snatching defeat from the jaws of victory in that situation. Repudiatory breach is when one party does something that goes to the heart of the contract so that it fundamentally undermines its operation and means that the innocent party can then choose either to bring the contract to an end or to allow it to continue. It's a one-time choice, and it's important to get it right and to do so promptly. You won't find the process for dealing with repudiatory breach in the contract. It's a common law concept, but we can look a little bit at how that would work. So I'm now going to take you through a bit of a whistle-stop tour of some examples of those contractual rights. So if we can go to the next slide, please. So this is the JCT Design and Build 2016 edition, although this is replicated pretty closely across all of the suite. A lot of other bespoke forms adopt a fairly similar form to this as well, so it's worth knowing this pretty well. So in circumstances where the contractor is not performing, you might be able to engineer a right to terminate. The key thing to note is it's not an automatic right. You need to follow the process and you need to serve the notices in order to gain the right to terminate. The first thing you need to do is to serve the notice of specified default. That sets out the action or inaction from the contractor which is in breach of the contract and which triggers one of the clauses that I've set out there on the slide. In the notice, you set out how it triggers that clause and how it reflects that. And then it requires the contractor to remedy that breach within 14 days of being served with the notice. So a fairly quick turnaround for most things, although there are instances where the breach is so serious that that may be too slow, and you do need to get advice then. Often you'll specify more than one of these triggers. So for instance, if you've got a contractor who's not turning up to site, you might rely both on the wrongful suspension ground that's set out there and also on the failure to proceed regularly and diligently. And you may be able to construct that both of those grounds are triggered. And if you can, better too. If the contractor doesn't remedy it within those 14 days, the employer then has 21 days within which to terminate the contract. Timing is everything here. It needs to be done within that period. If you allow that period to lapse, you can't just terminate because you previously had the right. There has to be a repeat. That may never happen, so you may lose the opportunity to terminate. And if that's something you really need to do, it can be quite damaging. If the repeat does come, generally, you will still be able to terminate, but that is a really tricky situation because repeats of defaults are very rarely identical. So yeah, you should give some thought then to taking advice at that point as well. Next slide, please. So this slide sets out the similar approach to termination by the contractor for the employer's default. You'll see it's a very similar process. A two-notice process again, so firstly the notice of specified default again, and then the termination notice. Again, there are strict timing limits which mirror the previous clause, and as you might expect, the grounds are somewhat more limited given the employer's obligations under the contract are potentially less extensive. In terms of the way it operates, though, it's very similar, and the key thing is making sure that these notices are served properly and in a timely way. You'll see at the bottom of the slide there that there's a bit of a foreshadow here to Kira's case law update that we'll hear from in a minute. There was a case that went through last year dealing with how this clause operates. I'm not going to steal Kira's thunder on that, but it's worth listening to that to understand this clause. Next slide, please. So we've looked at a sort of default situation. Now let's look at a couple of situations where everything's really gone wrong and the other party goes under. The key here for termination for insolvency is understanding what insolvency means, because insolvency doesn't always mean that the party simply can't pay their debts or that they've told you that they're going under. For the standard form contracts, generally a formal process needs to have taken place. So this is the JCT example, and here you're looking at a formal step of either, it says there, entering administration, appointing a receiver, passing a resolution, or making of winding up or bankruptcy orders. Those are formal steps, not the threat to do that, not a promise that it's going to happen, not even a formal notice of intention in respect to an administrator, for instance. So you really do need to make sure you don't jump the gun here, because if you do, again, we're back to that repudiatory breach point where you've tried to terminate for a good ground and not quite got it right. And again, you're causing yourself trouble by non-compliance with the contractual provisions. Generally, the best thing to do is to look at the Gazette or look for a court order confirming that any of these things have happened. Most of them have to be formally notified, so you generally can confirm from a third party that they have happened. Next slide, please. So this looks a little bit more about the way in which we then operate that clause. So here, if the contractor goes under, we'll come to the right to terminate in a moment, but there are also important automatic consequences to note. So as soon as the insolvency of the other side occurs, again, at the point where that formal order is made, they no longer have a right to be paid, and they no longer have to carry out any further works at that point. It is suspended. The employer then has a right to go into the site, secure it, and make sure that everything is safe and secure. That may give you enough breathing space to avoid having to rush into termination before you've taken advice. And also all of those things may avoid the risk of a repudiatory breach by accident if you go a little bit early. So it's worth bearing those in mind before you jump on the termination. If you do need to terminate, in these situations, it is a simple one-time notice to terminate, which will be effective upon receipt by the contractor. Next slide, please. Then we come to the employer insolvency situation. The contractual provisions here are very similar. However, the way they're going to operate is not. The thing that really changes the landscape here is the Corporate Insolvency and Governance Act, passed in 2020, which was passed in times of COVID for protection of those expecting to receive services, to ensure that there weren't termination provisions that enabled parties to terminate where the upchain party goes bust, and thereby causing further issues. In most cases, the contractor's right to terminate is likely to be ineffective, despite the fact that the contract terms are broadly the same as the employer's right. Sorry, the contractor's right to terminate. So it is a one where you really do need advice, because you might go about serving that notice thinking you're doing everything the contract says you should do, and in fact you'll get a reply from the employer saying, sorry, that doesn't work because of CGAP. Next slide. So this sets out the NEC example. The NEC is a very similar process. Termination in the NEC is set out by a process of reasons, procedures, and amounts. Here there are 10 reasons that relate to insolvency. The first 4 are individual insolvency, which is rarely used in the NEC context, given the types of projects that it tends to be used on. The final 6 relate to corporate insolvency and are more commonly used. They are, similarly to the JCT, they require a formal process to have been gone through, orders to be made, etc. So you need to be sure that that has happened again, avoiding jumping the gun. In terms of the way that this operates, you would need, again, to be careful about SEGA. It will overlay this in the same way it overlays the JCT arrangements, but insofar as you can do it, the process is quite straightforward, in that all you need to do is to serve a notice to the project manager, who then assesses whether or not there has been a right to terminate, and if they agree that one has arisen, they will certify the termination. That might give you some protection from jumping the gun, but it is still pretty dicey, so it's not carte blanche to roll the dice on it. Next slide, please. So you've managed to terminate. What next? As ever, it depends on the contract, and you'll need to follow the process in most cases. I'll come to some specific examples in a moment, but as a general rule, you need to think about some practicalities that apply almost universally. Firstly, if you're the employer or an outgoing contractor, you need to secure the site. 2 reasons really here. As the contractor, you've still got an obligation to third parties, so if you're terminating and getting off site and you leave it in a dangerous condition and somebody gets hurt, you may still be liable for that, even though you've come off site. Whereas if you do what you can to secure the site before you quit it, you are less likely to end up in that scenario. Similarly, if you're the employer and the site is left unsafe, you will want to secure it to avoid potential liability. You'll also want to secure it if you've terminated as the employer, because as we all know, there is a tendency for things to wander from site in circumstances of termination, particularly in insolvency situations where people are concerned that they haven't been paid. The key thing really is to make sure that you've insured the site as well, and the site remains insured. Most administrators and liquidators in insolvency situations will keep insurance running for a pretty short period, but you really shouldn't rely on that. You should get the insurance in place as soon as possible, and ensuring covers all of the risks that the contractor was going to cover under the contract. A good broker goes a long way here to make sure that you get that covered. If you don't have great contract terms and you don't have express terms for how this process is going to work, it can then become quite a complicated situation. So the post-termination landscape can be a litany of claim and counterclaim. It can get quite expensive and it can be quite uncertain. I know it's something we always say, but it's a good reason to make sure that the contract is in place and organised properly from the outset. Next slide, please. So this is the JCT example for what happens post-termination. This is the sort of split that you'll see in the JCT. The post-termination arrangements where there is an employer termination enable the employer to instruct others, requires the contractor to provide design documents, etc., requires the contractor to leave everything on site until specifically instructed to remove material from site, and requires them, if they can, to assign subcontracts back up to the employer. Nothing further becomes due, as we looked at previously with the automatic consequences, and then there is a reckoning process under clauses 8.7.4 and 8.7.5, where broadly the project costs that would have been incurred but for the termination are compared to the project costs that are actually incurred after the termination, and if there's a higher figure, then that is recoverable from the contractor. That generally is the case. Where the contractor terminates, many of the consequences are mirrored. The main difference is that there is a right for the contractor to remove all equipment, plant, materials that haven't previously been valued, which does give them a little bit more leverage sometimes in that situation. And the valuation exercise is about the value of the works left to be done and the lost profit that they would have obtained from that work. Next slide, please. So, as I talked about a minute ago, NEC is a matter of reasons, procedures, and amounts. We've talked about some of the reasons. There are an awful lot more that we haven't talked about today. The procedures and amounts are what cover what happens after termination. The procedures deal broadly with who can do what and when. It's about whether you can remove materials from site, whether materials that are on site can be used, whether equipment that's on site can be used. Those are clauses P1 to P4. And then the amounts are set out in terms of the amounts that can be recovered. They broadly split very similarly to the JCT in that the ones that are used for termination by the contractor, for instance, enable the contractor to recover the lost fee that they would have incurred or would have obtained on the balance of the work. In order to work out which of these procedures and amounts you use, the NEC4 has a very nice table at clause 90.2, which really gives an easy, ready reckoning of which processes and amounts to use. So have a look at that. Broadly, it works out that the contractor is going to get more if it's an employer default or if the employer is terminated for its own convenience. The employer is going to recover more if it's terminated for contractor default. Next slide, please. So just to wrap things up and in conclusion, know what your contract says and have a good contract in place in the first place. Follow it, do what the contract says you should do. Follow it strictly and make sure you adhere to the timing. So wait, but don't wait too long. Don't jump the gun, but also don't let that opportunity slip out of your hands. And then finally, as I've touched on a couple of times, it's a complicated area with huge ramifications. So advice early, as soon as you know that it might be necessary, really is important. So that's the end of my presentation, but let me pass you over to Mark, who's going to talk about the insolvency landscape in the construction industry.
Okay, thank you, John. Good morning, everybody. I'm just going to talk through some of the situations that we see and how we approach dealing with financially distressed businesses in the construction sector, and just some practical issues that we face from an insolvency practitioner's point of view. I'm clearly not going to be able to go through everything, but hopefully we'll give you a flavour of what we do and what we see, and give you some useful takeaways. Next slide, please. So I'm a partner at Ensors. We've got offices throughout East Anglia, 6 offices in East Anglia, 270 staff. Again, we're a kind of full service offering from an accountancy point of view. So everything you'd expect, plus specialist teams, one of which is mine, in the turnaround and business recovery sector. Next slide, please. In terms of me, as I say, I'm an insolvency practitioner, been working in recovery and turnaround for more than 25 years, most of that, as I say, in East Anglia. And in that time, I've obviously seen a myriad of businesses, probably very little that I haven't seen, and quite a lot in the construction sector as well. Next slide, please. In terms of what we're going to look at, I'm going to start looking at some insolvency stats and a few pointers from that, particularly in relation to construction. And then, as I say, just going through what we do, what we see, how we get involved, practical matters that we need to address, practical issues, commercial issues that we encounter, problems, all sorts of things, and also just really picking up on some warning signs for those businesses that you might be dealing with, a distressed businesses. Well, what sort of things to look out for. Next slide, please. So straight away onto the stats, and you can see there. So these are the statistics produced by the government in terms of formal insolvencies. These came out in January of this year, so our full year figures. And you can see for 2023, in fact 22, 23, that there has been certainly an increase in formal insolvencies. We have seen that. And of course, the reasons for that are reasonably clear, I would say. From 22 onwards, there's been the release of the financial support that companies were able to avail themselves of during the pandemic. Those have been taken away, and of course, then we've got rises in interest rates, material costs, wage inflation, general political and world political upheaval and political events, and a general sort of lack of confidence, I would say. But I do think 2023 has probably peaked. I do expect the numbers to continue to be relatively high in 2024, but probably not of this order. So hopefully some relatively good news there. Next slide, please. So then translating those figures to specifically the construction sector, and again, there's it's the full spectrum of businesses involved in construction, and you can see from that table, hopefully, that again illustrates what a challenging environment construction is and always has been, because those numbers there show very clearly that construction has always been the highest proportion of formal insolvencies. Now, and again, that kind of mirrors what we are seeing in our practice and the advice and businesses that I'm working with. Over the last year, 2 years, we've worked with some large house builders. We've worked with M&E contractors. We've worked with groundworks businesses down to small owner-managed businesses, just providing general services. So every kind of business related to construction has been affected, and I think, as John alluded to, we kind of all know it's still a difficult sector. Next slide, please. So that's the kind of background in terms of the stats. I guess moving on to what we see in practice and how do we get involved. First thing there, it's always about the cash. Now, that's not unique to construction business, of course. My job is dealing with distressed businesses. So this talk is all about that scenario or that environment. And it is always about the cash. It's when are we going to run out of cash? How can we manage cash? How can we generate additional cash? And in terms of what we're able to do, it very much depends on when people come to us along that cash timeline. If a business is recognizing that in 3 months, 6 months, a year, it might have cash issues or is going to have cash issues, then that gives us a very different environment to work in than a business that is come to us saying, look, run out of cash, exhausted all our revenue generating opportunities, we've got there's delays in payments coming in, but we've got wages to pay next week, we've got suppliers shouting at us, we're on stop, we've got people walking off site, exhausted, as I say, all our funding opportunities. In that situation, very difficult really to do anything positive with. And again, we get to look at everything in between those two extremes. But what we will always do is first and foremost look at the forecast, carry out that financial review, try and establish the level of distress, because that's going to govern the advice and the options that we have. We're going to be first and foremost looking at funding, but first and foremost looking at where are we with the contracts? What's the position, and what's the reality of whether it's a single contract, whether it's a number of contracts, what's the reality of what can be achieved given the financial restrictions that we've got. And as I say, really looking at the funding requirement, but looking at engagement with stakeholders. That's absolutely key. You know, the worst outcome is always achieved by burying heads in sand, not communicating. So we would always encourage communication, and that might be communication with HMRC about putting payment plans in place, communicating with suppliers, with everyone that's involved in the business, because we can put payment plans in place. You just have honest conversations. We might be going to employers, being very frank about the position, but you know, that conversation might be in terms of, well, I've said before, accelerating payments, possibly renegotiating contracts, but that's a stretch, of course. As I say, we'll be looking at cost cutting, so and bringing employees into the equation. So it's bringing everyone along with the journey, because although you know, I am an insolvency practitioner, but our first and foremost objective is to avoid insolvency, enable the business to carry on trading as a going concern. Yes, in a difficult, tricky situation with some difficult conversations, but the ultimate goal is to salvage the business in some way, shape, or form. Next slide, please. So in terms of how we actually get involved in the engagements that we secure, first and foremost objective, as I've said, is to avoid insolvency. And so we might be, and again, this is all about timing, it's all about funding fundamentally. We've had assignments where basically we've just been providing advice in the background. We've been a sounding board, an insurance policy to the board of directors, giving them some do's and don'ts, but also getting involved in those negotiations and discussions. So be it with employers, be it with HMRC, because actually having us sat around the table in those discussions gives that sort of third party view, gives that bit of credibility, and you know, from the point of view of us frankly being able to say, well, actually, if you don't buy into this plan, the next outcome is going to be formal insolvency, and that is a worse position, inevitably. But I've got to be honest, in terms of the majority of situations we see, then some sort of formal insolvency process is possibly the outcome. But again, we're looking at, well, what's the hierarchy? What are the possibilities? And you know, first and foremost, again, if we're looking at insolvency, we'll probably be looking at administration, and certainly, you know, administration with a view to a sale of the business. You know, obviously, the liabilities will not be taken on by any buying party. They'll just be buying the assets, or some of the assets, including the contracts. But that's kind of what we're trying to achieve, and that might be through a pre-pack administration. So we would be involved pre-insolvency, negotiating the deal, setting things up, and then on administration, going through with a sale or being party to the sale, but then taking a step backwards, leaving the ongoing trading, dealing with contracts, dealing with suppliers, excuse me, with the purchasing party. Now, again, obviously, it's an insolvency scenario, so not by any stretch of the imagination suggesting it's a smooth path, but that would be the aim. And we would also look at, if we can't achieve a sale, well, then we get into the, can we trade some of the business on in administration? Can we complete some of the contracts in administration? And I'll come on to that in a minute. And it's all to do with, well, it's going down that hierarchy of what is going to achieve the best outcome for creditors of the insolvent entity. How can we best achieve that and secure that? But of course, again, very honestly, going back to that situation where people come to us very late, we are quite often dealing with cessation, and picking up on some of the points that John mentioned about termination. In a liquidation, if we simply do not have the funds available, do not have the profitable contracts that we might be able to continue with, then cessation, liquidation could well be the outcome. And of course, go into that with open eyes, because when we are looking at a liquidation scenario from our point of view in terms of completing work in progress and contracts, well, that's unlikely. You might be able to achieve some completions in the pre-appointment period, but generally not, or generally not on a large scale manner. And then obviously looking at collection of book debts, of amounts due under contracts, then in that termination or cessation scenario, very well aware that there are going to be counterclaims, claims for damages, and whatever book value we may have is going to be eroded very, very quickly. Next slide, please. So in terms of kind of the practical challenges that we come across, and here I'm really talking about a scenario of us going in as administrator with a view to completing some of the contracts we've got. And again, that's a difficult scenario to walk into, because termination is a prospect. We've, as administrators of insolvency practitioners, have got to convince the employer that we can complete the contract, and the outcome of us doing that is going to be in the best interests of everybody. It has to be in our interests as administrators financially. We need to, or we will only complete contracts that are going to generate income for us. So we are going to be unfortunately walking away from contracts that aren't profitable for us, don't generate anything for us, or the insolvent estate. So again, it's back to that communication piece and analytical piece of identifying the contracts that are going to generate some income, and I think those full and frank discussions with employers, and fully aware that the employer does have the right to terminate, but I suppose ultimately looking at a situation where if we're unable to complete, then as John said, the employer is looking at new contractors, more expense, longer time frames, and things like that. So in terms of completion of work in progress and contracts in administration, then yes, that's entirely possible, but it needs the will of several parties. And one of those parties is inevitably going to be employees. We need to bring them on the journey, and also subcontractors. Because again, the reality is that we might be asking people to come on site and complete work who are owed several tens of thousands of pounds. And whilst I can say to them, well, of course you'll get paid for the stuff that you do in the administration, they're quite rightly and understandably going to say, well, that's fine, Mr. Upton, but what about that 50,000 that I'm owed already? But in those scenarios, we will certainly be willing to look at making what we call duress payments to get people on site, to get these contracts completed, which would have all been factored into our analysis of what income that contract is going to generate. So it's all about engagement. Again, accepting fully that there's going to be some disquiet. There's going to be people that have lost a lot of money, but it doesn't need to be adversarial is really, I guess, my point, and that's from an employer and a subcontractor point of view. But again, quite a lot of it is around funding, and one of the things that we might be looking to do is to talk to employers and looking for them to basically certainly pay on applications that have already been made, pay for work done that's already been done, but potentially pay for work in advance as well. And again, accepting that we need to be very convincing in terms of demonstrating that the contract can and will be completed. Next slide, please. So other kind of practical issues that we come across, I've talked in those last couple of slides about completing contracts and completing work in progress, but that there are other matters and challenges for us as IPs in a insolvent situation. And I suppose the principal one, again, relating it back to termination, is the collection of outstanding debts and amounts due to the insolvent entity. And I think that the main point to say there is that we have a duty to realise assets, so we will be looking to pursue and collect any outstanding debts. But again, accepting that it's a lot of circumstances, there's going to be counterclaims, set-offs, etc. But I think the point is we're not going to walk away from them. If you're the debtor party, then it's insolvency is not an excuse just to walk away from a debt, because it will be pursued, and we've had situations where we would certainly be scrutinising any counterclaims, any costs that are presented to us. So we will be looking at appointing QSs, and we have gone to adjudication before. So yes, we will be accepting in an imperfect environment, but we will be pursuing those debts. Other area is certainly retention of title and ownership of materials and other assets, because there's questions always of identification, there's questions of location. We as IPs haven't been in control of those assets, so determining what those assets are, where they are, whether they've been incorporated, who physically owns them, have they got competing claims, all of that does present an issue. And again, picking up on one of John's points in terms of access to site, if we have walked away from a contract, then likelihood is that we're not going to have access to the site itself. So us recovering plants, recovering assets is quite tricky. And of course, us going on site to recover those assets, or agents to instruct, in itself is disruptive and challenging. Next slide, please. So just finishing off, in terms of looking at what a whistle-stop tour of what we deal with and what we encounter, I suppose for people dealing with potentially financially distressed businesses in the construction sector, what are the warning signs? And some very simple and obvious ones. It's are people late in paying? Are they paying actually on account, making round sum payments? Because that's quite a red flag. It just is a bit of a warning sign and an illustration that there is financial difficulty, because they're trying to spread the cash they've got amongst all of their suppliers. And then obvious ones about employees, subcontractors not on site, work stopping, materials not on site, all of those things, maybe of themselves as an isolated incident, maybe not an absolute indicator, but taken all together, there's some real warning signs there. And then it's how do you address those? What responses are you getting? Literally, is the phone being answered? What are the directors telling you about the issues? Does it make sense? What's the industry chatter? Because it's never usually wrong, quite frankly. And it's using all of those to really gauge, well, is the business that you're working with, is the business that you're just about to make a very significant payment to because they've been chasing you for it? Are they going to be on site the next day? Because they may have somebody like me sitting with them, pressing them to get the cash in, get the cash in, get the cash in, because that then is the point at which insolvency might be triggered, and you don't want to be paying away all that cash and then experience all the difficulties that non-completion of a contract might entail. Next slide, please. So, as I say, a bit of a whistle-stop tour there, but summary, well, yeah, we know the construction sector's hard. It always has been. It's been challenging for all the reasons, economic reasons we've had over the last couple of years, and I do think it will carry on over the next little while. If you're dealing with a distressed business, as I say, be mindful of that cash cycle. Look out for those warning signs, and be quite circumspect in your dealings with them. And don't be afraid to ask questions, ask difficult questions. But as I say, formal insolvency is not always the end of the story. If it's administration, we'll be looking at a sale, a pre-pack sale, or a continuation of contracts, but certainly accepting that there might be contracts we're going to have to walk away from. But we're always looking to find a positive outcome, and we will always be commercial. But again, always the cry of somebody working in professional services. Any business that is in financial distress must take advice early, because it gives us many more options in terms of timing and opportunity with which to explore positive outcomes. So hopefully that's been useful. Thank you all very much for listening, and over to Kira.
Hi everyone, I'm Kira. I'm a solicitor in the construction team, as Catherine mentioned earlier, at Birketts, and I'm going to be taking you through a quick case update today. Can we have the first slide, please? So the first case we're going to look at today is Providence Building Services and Hexagon Housing Association. As John mentioned earlier, this links nicely to his discussion on termination, as it concerns the circumstances in which a contractor has the right to terminate under a JCT design and build contract, or not, as it would turn out. Sorry for the spoilers. But in this case, Hexagon was the employer and Providence was the contractor. And Providence issued a notice of specified default under clause 8911 of the JCT following Hexagon's failure to pay a payment application. And clause 8.93 of that contract allows the contractor to terminate by notice where a default isn't rectified within a certain time frame, being 28 days in the amended clause in this case. In response, Hexagon made payment in full within the time frame, thereby rectifying the default as required under the contract. However, later, Hexagon failed to make a payment against a different payment application, and Providence issued a notice terminating the contract under clause 894, which provides that if the contractor does not give the further notice referred to in clause 893, being the notice to terminate where the default has not been rectified, but then the employer repeats the default, then the contractor can give the notice to terminate for that reason. So Providence was relying on the fact that Hexagon had failed to pay on time twice as the repetition of the specified default under 8941, notwithstanding that Hexagon had ultimately paid the first application within the time frame required and rectified the default. Can we have the next slide, please? So following some back and forth on this, Providence took steps to leave the site, and Hexagon issued its own notice of acceptance of Providence's repudiatory breach. In the subsequent adjudication, the adjudicator found that a right to terminate must have accrued under 893 before an entitlement to terminate under clause 894 arose. I have the amended version of that clause up on the slide for you, because that would be your starting point if you were using this contract. But as mentioned earlier, in this case, the clause allowed termination if the default was not rectified within 28 days. But because Hexagon had rectified within that time, the adjudicator found that a right to terminate had not arisen under this clause. Providence initiated proceedings arguing that Hexagon had committed a specified default, and even though Hexagon had remedied that default, Providence was entitled to terminate because Hexagon repeated the specified default by failing to pay a second time. The court disagreed and ultimately found the same as the adjudicator. Hexagon had rectified the initial specified default, so the initial right to terminate had not actually accrued, meaning that no right could accrue under 894 either. And in making this decision, the judge stressed that contractors already have protections under the JCT, such as the ability to suspend and adjudicate for late payment. And the interpretation of clause 8.9 by Providence was found to enable the contractor to terminate their employment too easily, and Providence's termination notice was declared invalid. So it's worth bearing in mind that this permission to appeal has been granted on this case, so watch this space. But in terms of what it tells us about termination for now, this decision should really be a warning to be very cautious about attempting to terminate under a JCT. If you're a contractor, there are other options for recourse if you're not being paid. And when it comes to trying to actually terminate your employment, this is not easily done. As John mentioned earlier, the message here is really that you should get advice on termination, even if you have a very good reason to terminate, because that won't really matter if you don't go through the process properly. You could find yourself defending a very expensive wrongful termination claim, despite the other side arguably being the ones in the wrong or more wrong, depending on your view. So that's that one. Can we have the next slide, please? So this case is Bellway Homes and Shergo Construction. If you're looking this up later, there are two recent cases with this name. This is the earlier of the two, decided in January, I believe. So just bear that in mind. So Shergo engaged a company called Roundel Manufacturing to supply and install kitchens for a building development. Roundel made an application for payment, and Shergo did not submit a valid payment notice or pay less notice, and they didn't pay anything, I believe. Roundel referred the matter to adjudication on a smash and grab basis, i.e. that because the payer didn't issue any payment certificate or a pay less notice, then the applied for sum becomes a certified sum and is payable. However, they also asked that if the adjudicator were to decide that the smash and grab claim was not made out, that he considered that what the sum due was on a true value basis. So the adjudicator should assess what the value of the works actually was and order payment accordingly or not. So Shergo raised a jurisdictional challenge to this referral. They argued that there was no jurisdiction because Roundel was effectively referring multiple disputes by referring a smash and grab and true value argument in the same referral. The adjudicator disagreed and found that he did have jurisdiction, and ultimately found in Roundel's favour on the basis of the alternative argument. So he found that their payment application was not actually valid, but that the true value of the claim was the sum applied for, and Shergo was therefore ordered to pay that amount. Roundel then assigned their interest in that decision to Bellway Homes, and they applied to enforce the decision. The judge found that the adjudicator did have jurisdiction to decide the dispute, and said that the alternate grounds of Roundel's claim had ultimately been two ways of determining the same question. So they were not two separate disputes, and that it would be taking an approach that is too legalistic to interpret a smash and grab and true value argument as separate disputes. So the main reason that this case is so interesting to us is because whether you can include a smash and grab and true value argument in one referral hasn't been confirmed until now. This decision is a really strong indication that in some circumstances, at least, we will be able to do that. Whether or not we are likely to see this approach actually taken very often remains to be seen. A true value adjudication is often very technical and expensive. You may need experts, and you're likely to have high legal costs and adjudicators' costs because of the substance of a true value claim often being quite complex. Whereas the advantage of a smash and grab is that we can generally pull them together relatively quickly and relatively inexpensively. And for this reason, referring parties may still only want to go down the smash and grab route in the first instance, even if they have both claims to a sum of money. However, if a referring party claims that they have a procedural entitlement to payment and a substantive basis on which to claim for the same work, in limited circumstances, this may now be an effective way to ensure that you get paid something, and it's certainly something that will be considered when we're preparing referrals in similar circumstances now. Can we have the next slide, please? Thank you. So the last case is CLS Civil Engineering and WJG Evans and Sons. This case concerned a development where the parties were in agreement that the works would be undertaken under a JCT intermediate contract, but they weren't agreeing on certain key terms. So in order to get started, the works commenced under a letter of intent, and this stated that the employer would not be liable to pay more than £150,000 under the LOI. However, as time went on, the terms were still not being agreed, the terms of the JCT. And to keep the project moving, the employer was extending the liability cap to 300,000, 500,000, and ultimately to 1.1 million. And this was over the course of 14 months. So during this time, the contract had not been finalised. So that's a long time to be working without the comfort of a contract. And eventually CLS terminated the contract. WJG asserted that CLS was in repudiatory breach in doing so, and they sought 1.4 million by way of their termination account. So they were saying that they had done around £300,000 more in work than was the liability cap under the LOI. And CLS brought a claim seeking declarations that there was no construction contract other than the LOI and that their maximum liability was 1.1 million. WJG put forward various arguments that there was a contract on various different grounds and that they were in any event entitled to further payment. Can we have the next slide, please? So the judge found that the JCT terms had not been agreed and that the terms of the letter of intent were therefore binding. The original letter of intent had made clear that CLS did intend to enter into a contract, but on terms that were to be agreed. The judge considered that WJG had accepted the offer to be paid up to a maximum initially of £150,000 by having started the works. The further cap increases up to 1.1 million were also found to be accepted because contemporaneous correspondence made clear that WJG were aware of the limits as they changed and were apparently working to them, because they were sending emails saying things like, we're approaching the cap now, can we have an extension on the cap? And in those circumstances, the judge found that all work undertaken over that cap had been at the contractor's risk. So this case is a clear reminder of why we would generally steer clients away from entering into letters of intent wherever possible. Obviously, there's a lot of concern about cost and delay when contract negotiations are taking longer than expected, but that risk is often going to be preferable to the risk of working without the protection of a contract, as in this case. That's everything from me. I think we're going to come back together now for some questions.
Thank you very much to all the speakers. There was a lot to get through there. I hope it was of interest. Very conscious of time, so I'll just keep to a couple of short questions. And as I said previously, if we've got any follow-up, please do contact us. Our details are on the slides. John, if I can come to you first, the questions come in around the position on delay damages at the point of termination. I wonder if you can just clarify that, please.
Yeah, so it is a relatively complicated one, but the contracts generally provide for how delay damages are to be deducted. And in most circumstances, if those steps have already been followed prior to the termination, then the delay damages will be deducted as part of that overall calculation at the end of the termination account process. However, if they haven't been notified, then that can be more difficult. And where the delay arises as a result of the termination, so if the project was not in delay at the point of termination, but because of the termination it is delayed later, delay damages may not be recoverable as liquidated damages post-termination, but they should be potentially recoverable as general damages if an actual loss can be proven. For instance, on the JCT contract, the contract clause provides for recovery of any loss or damage suffered by whichever party it is as a result of the termination or otherwise. So if there is a delay that can be ascribed and a cost that can be applied to that, it should be recoverable in the calculation. But it is rather more complicated than simple delay damages.
Thanks. Mark, if I can come to you. You made a point around making potential duress payments to suppliers, and a question has been raised about whether that would not be classed as a preference.
Fundamentally, no, is the answer. I mean, when we're looking at duress payments and certainly payments where we have already been appointed, then it's a commercial judgment for us to kind of establish, well, what's the benefit of this payment, and if there's a greater realization than that's going to be achieved, or an additional realization that can be achieved, then we will make those kind of duress payments. It's down to kind of commercial judgment rather than it being a preference, because technically a preference is a payment to a creditor to put them in a distinctly better position than otherwise it would have been. This in terms of what I'm talking about there, it's kind of a commercial judgment as to whether to make that payment.
Thank you. And then very quickly, Kira, you mentioned obviously we try and avoid letters of intent, but could you give us a couple of bullet points about how you minimise risk if you do enter into one?
Yes, so we would say that if you must, and we would say don't, but if you must, refer to the terms that are agreed, maybe by reference to a standard form like a JCT, carve out any terms specifically that aren't agreed, and also specify what works are being undertaken under the letter of intent. That way, if there's any dispute about anything that is agreed, no one can argue that they didn't know what the applicable terms are. And if you're the contractor, make sure that you're keeping a very close eye on the costs as they approach the liability cap, and make sure you're able to stop works once you've reached it, as anything else will be at your own risk.
Perfect, thank you. So I think that's all we've got time for today. Sorry we've slightly run over, but we hope you found this morning's session informative. When the session ends, you'll be invited to submit your feedback. That's really helpful to us, and if there are particular topics you'd like us to look at for future sessions, please let us know. We thank you all again for joining us today. Coming up next will be our summer webinar, which for CICS is on the 26th of June, so date for the diaries. And I expect we will no doubt be talking about the new JCT suite of contracts then, which we heard last week will be out in April. So one to look out for. Thanks very much, and thanks again to all the panelists this morning. Thank you.
Thank you.